I'd like to say a few words about President Trump's appointment of Matthew Whitaker as acting Attorney General before turning to today's agenda. There is good reason, I believe, to be concerned about the President's appointment of a political appointee who was not Senate confirmed and clearly is biased against the Mueller investigation. To start, it's not clear that the President has the legal authority to elevate Mr. Whitaker to act as Attorney General. Yesterday, the administration issued an opinion from the Office of Legal Counsel that defended the President's right to appoint Mr. Whitaker by focusing on the temporary nature of the appointment. They then relied on the Vacancies Act. However, many legal experts have argued that only Senate-confirmed officials can serve as Attorney General, even in an acting capacity. In fact, the plain language of the Appointments Clause in the Constitution and subsequent statutes enacted by Congress, establishing the confirmation of the Attorney General and outlining the proper succession at the Department of Justice, make it clear that to have the authority to act as the Attorney General, the individual must be confirmed by the Senate. Already this question is being litigated and challenged in court by the state of Maryland. But what's worse is while the legal question makes its way through the court system, the validity of all actions taken by the department under Mr. Whitaker's leadership will be challenged and called into question. And there's an easy way to solve the problem. Rod Rosenstein is confirmed by the Senate and is serving as the Deputy Attorney General. He should serve as acting Attorney General until Mr. Sessions' replacement is selected and confirmed. Beyond the legality of Mr. Whitaker's appointment, there are also serious concerns that the President selected him because he's loyal to the President and will act to undermine Special Counsel Mueller's investigation. While serving as Mr. Sessions' Chief of Staff, Mr. Whitaker had a reputation as the White House's, quote, eyes and ears at the Justice Department. The President also reportedly told aides that Mr. Whitaker was loyal and would not recuse himself from overseeing the special counsel's investigation. Mr. Whitaker has been openly hostile to the Mueller investigation. He has said that this is a quote, the investigation is going too far and should be limited. He also suggested that President Trump replace Attorney General Sessions with someone who, quote, reduces Mueller's budget so low that his investigation grinds almost to a halt, end quote. Mr. Whitaker's record also raises troubling questions about his potential misuse of official authority for political purposes. Iowa State Senator Pat McCoy has alleged that while U.S. Attorney, Whitaker targeted him for prosecution because he is an openly gay Democrat. Mr. Whitaker reportedly pushed his U.S. Attorney position to promote business from a private company, World Patent Marketing, and threatened customers with, quote, serious civil and criminal consequences, end quote, when they complained about the company's business practices. A federal judge fined the company nearly $26 million and shut it down last year. The FBI, which Mr. Whitaker now supervises as acting Attorney General, is currently investigating the company. The American people ought to be able to have faith that the person serving as Attorney General, even in an acting capacity, will enforce the law excuse me, in an impartial and even-handed manner. There are serious questions about the motives for appointing Mr. Whitaker, as well as his fitness for the position. I hope the chairman will grant my request to hold hearings as soon as possible with Mr. Whitaker and former Attorney General Sessions. I also want to briefly address two nomination hearings that this committee recently held while the Senate was in recess. It's been suggested that I agreed to hold these hearings during recess. That's not true. Rushing strike that last word. When hearings were originally scheduled for October, it appeared that the Senate would be in session. While I agreed to in-session hearings on October 17 and 24, there was no agreement about what to do if the Senate adjourned. After Senate leaders agreed to recess in the month before the midterm election, Judiciary Democrats asked the chairman to reschedule the October 17 and 24 hearings. The request was denied. As a result, these hearings went forward, even though no Democrats and only 3 Republicans were able to attend. This means that 85% of the committee was not able to question these nominees, who are seeking, after all, lifetime appointments to the federal bench in a public session. So the point is, no Democrats and only 3 Republicans were able to question him in a public setting. Some of these nominees are controversial. There are serious questions about the qualifications of Allison Jones Rushing, a nominee to the Fourth Circuit who appeared at the October 17 hearing. Ms. Rushing is just 36 years old. She's only practiced law for 9 years. Eric Miller, who appeared before the committee on October 24, is opposed by dozens of Native American tribes because of his record on matters involving tribal sovereignty. Democratic members have asked for second hearings, so all members have a meaningful opportunity to question the nominees who appeared before the committee during the Senate recess on October 17 and 24. Mr. Chairman, I very much hope that this request will be granted before the committee votes on their nominations, and I thank you.